Thank you for joining us today. I'm going to make introductions of the board members and then make a couple of announcements. I'll be starting to my right, your left. The far end is David Kittner. Next to him is George Taylor and Jack Cruz, Gary Gerwitz, Deborah Race. Vice Chair is Joelle Cannon Sheridan. I'm Clark Lee and Tom Williams, Kathy Owens, David Shawnette, Marty Jones, and Rhea Chevaria. Thank you for joining us today. Let me go ahead and take announcements on 50489, the respondent.
Good morning. My name is Pete Schulte, SCHULTE. I represent Suzanne Wooten. We're ready to proceed.
And for the movement.
Good morning. Rebecca Stevens here on behalf of the Commission for Lawyer Discipline. We are also ready to proceed.
As you both know, we have given each side 2.5 hours. We'll be keeping time over here. If you need a report on time, we're happy to give that to you. Anytime that we are making a ruling or spending time, we'll pause the time so that no one will be charged for that. Basically, if you're talking, then it's your time. If you're making an objection, then it goes on your time. Openings, closings will count 2.5 hours. Since we have a strict time limit, we will probably be a little bit more lenient on objections and allowing things. That doesn't mean that they're necessarily admissible, since this is a trial to the bench. If it is irrelevant testimony, it may well be ignored when it comes time to make a determination. So it's your time. If you're spending a lot of it on irrelevant information, you do at your own peril. Yes, sir.
Just for procedural, I'm type 1 diabetic. I'm just for kind of the game plan for lunch and that sort of thing, since I know we're starting at 10 a.m. I was curious what the board was thinking about time today. I do have to eat lunch at some point.
Yeah,
so.
we're probably going to take lunch about noon.
Okay, fair enough.
Yeah, somewhere around there. And listen, if anytime, we aren't just terribly formal. Anytime if you need a break, then
You don't want me falling over, I understand.
Exactly. And falling over brings up another point. We are recording this. And we post our recorded hearings on our website. So if you do fall over, people will be able to see you, due time. So we are recording it, which means that we ask that no recordings other than the official recording be made during the hearings today. Do you have any questions? Okay. Why don't we go ahead and start the hearing, and Ms. Stevens.
May it please the board, counsel. Rebecca Stevens here on behalf of the Commission for Lawyer Discipline. And as a preliminary matter, we would invoke the rule and ask that the board swear in the witnesses.
Are there any witnesses in the courtroom?
Yes. There are. I mean, if we're going to vote the rule, I'd like to have my witnesses at least introduce themselves to the
Yes.
board before they leave.
Okay. Why don't you go ahead and identify your witnesses, and we'll have them sworn and ask that they depart.
Richard Corbett.
On behalf of Suzanne. Robert Henry. On behalf of
Susan Rankin. Dave Matthews Bridges. Christine Almano. Tricia King.
Alan Taggart.
Dawn Fowler.
Manuel Gonzalez.
Any other witnesses? Do you have any live testimony?
They're not in here. We have some possible rebuttal witnesses, but they're not here.
Okay.
Would you go ahead and swear the witnesses?
Do each of these solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. The rule's been invoked, so y'all will need to leave the courtroom. We'll call you when it's time, and we'll make sure that you're, keep an eye out for you. Okay. And before you leave, if you testify, when you leave, don't talk about the case or what your testimony was. It's so that one witness isn't contaminated. So If you do testify, don't say what happened until the hearing is completely over. Mr. Schulte, will your client be testifying?
I have no plans to call her.
Okay, okay. I didn't want to neglect to swear, you know.
I
think
appreciate that, but I don't know if the state bar has plans to call her,
Okay.
but I do not.
Okay.
May I
Stevens?
proceed?
Yes.
Members of the board, this is a compulsory discipline case brought pursuant to Section 8 of the Texas Rules of Disciplinary Procedure. This case is based on respondent's convictions in the 366th District Court of Collin County, Texas, for 1 count of engaging in organized criminal activity, 6 counts of bribery, 1 count of money laundering, and 1 count of tampering with a governmental record with intent to defraud or harm. The petition for compulsory discipline was filed with BODA on May 23, 2012. Respondent was personally served with the petition and notice of hearing on May 31, 2012. Respondent filed her original answer on June 4, 2012, and proof of service has been on file since June 20, 2012. On July 14, 2011, respondent was charged by grand jury indictment, superseding indictment, with engaging in organized criminal activity 1 count, bribery 6 counts, money laundering 1 count, tampering with a governmental record 1 count, in case 366-81639-2011, styled the State of Texas versus Suzanne H. Wooten in the 366th Judicial District Court of Collin County, Texas. Respondent was then tried by a jury, and the jury found her guilty on all counts. Thereafter, respondent and the state came up with a punishment agreement. Since respondent was a sitting district judge at the time of her conviction, as a condition of the punishment agreement, respondent was required to resign her bench. On December 6, 2011, 9 judgments, 1 for each count, were entered. For count 1, engaging in organized criminal activity, a 2nd-degree felony, respondent was sentenced to 10 years TDCJ institutional division, with the sentence of confinement suspended for 10 years, ordered to pay a fine of $10,000 and court cost of $236, with the sentences to run concurrently on all counts. For counts 2 through 7, all of which are bribery 2nd-degree felonies, and count 8, money laundering, a 3rd-degree felony, respondent was sentenced for each count to 10 years TDCJ institutional division, with the sentence of confinement suspended and respondent placed on community supervision for 10 years, in order to pay a fine of $10,000 with the sentences to run concurrently on all counts. And lastly, for count 9, tampering with a governmental record with intent to defraud or harm, a state jail felony, respondent was sentenced to 2 years TDCJ state jail facility with the sentence of confinement suspended and respondent placed on community supervision for 5 years in order to pay a fine of $10,000 with the sentence to run concurrently on all counts. On or about November 28, 2011, 9 separate orders suspending imposition of sentence and placing defendant on community supervision were entered for each of the 9 cases, 1 per count. Respondent was ordered as a condition of community supervision to perform 120 hours of community service per count. Respondent has waived her right to appeal, and these convictions are final. All 9 of the counts are felony crimes involving moral turpitude. The Supreme Court has said that crimes of moral turpitude generally, quote, involve dishonesty, fraud, deceit, misrepresentation, deliberate violence, or that reflect adversely on a lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects, end quote. Each of these crimes involves dishonesty, deceit, and adversely reflects on an attorney's honesty and trustworthiness. Therefore, they are crimes of moral turpitude. Further, all 9 counts require intent or knowledge as an essential element of the crime. Thus, each of them is an intentional crime as that is defined by the Texas Rules of Disciplinary Procedure. Additionally, this board has previously held that each of these crimes, engaging in organized criminal activity, bribery, money laundering, and tampering with a governmental record with intent to defraud or harm, are intentional crimes. Since all 9 counts are intentional crimes and respondent's sentence was suspended, pursuant to the Supreme Court's decision in Caballero, BODA has the discretion to disbar or suspend respondent. As you're aware, one of the factors that BODA looks at when determining whether to disbar or suspend is whether the crimes are directly related to the practice of law. Article 5, Section 7 of the Texas Constitution requires that in order for a person to run for district judge, that person must be licensed to practice law in Texas. The evidence, specifically the indictment and the judgments, will show that respondent's crimes are directly related to the practice of law. In that, she was running for district judge at the time crimes were committed, and the crimes were committed in furtherance of her campaign for judgeship. I'd like to note that it's the Commission's position that pursuant to the rules, this is not a forum to relitigate the underlying convictions. The 12 members of the jury in the underlying case have already convicted respondent of these crimes. We will strenuously object to any attempt to collaterally attack those convictions. Lastly, I'd like to emphasize that through the disciplinary system, we are called upon to protect the integrity of our profession. We're also called upon to protect the public. Allowing respondent to keep her law license after these convictions would undermine both of those callings. At the close of the evidence, the Commission will ask the Board to exercise its discretion and disbar respondent Suzanne Wooten. Thank you.
Thank you. Mr. Schulte?
Thank you. May it please the board, counsel. Discretion. That's why we're here this morning. This was a slam dunk like the state is alleging that it is because there's convictions. There would be no need to have a hearing. No need to have a 5-hour hearing, which I know is very rare for this board. For you to exercise your discretion, which means to either disbar or to suspend Judge Wooten for the period of her probation, which there's no dispute here that her sentence was fully probated, so it is under the rules. You do have to look behind the conviction. I have no intent to relitigate what happened, but I think every lawyer on this board understands that sometimes juries do get it wrong. And if I had a jury of 12 lawyers, you're going to hear evidence from judges. One judge in particular, district judge in Collin County, as we go through this hearing, that said, there is no way these bribery counts would withstand appeal. He's board certified in criminal law. The politics of Collin County are amazing. Something that I had never seen before. I grew up in Collin County. I was born in Plano. Judge Wooten ran for office in 2008 to get rid of a tyrant of a district judge. First time ever in that county's history that a sitting district judge was challenged. How dare she, for the first time in that county's history, challenge an incumbent? They were enjoying their appointed judicial system in Collin County where a new bench would be opened up and the governor would appoint and that judge would get to stay there for life. Things were changing in Collin County. You'll hear evidence that this particular investigation, which I will categorize as a witch hunt, I will get disagreements from the state bar on that, but you will hear evidence about how long this process took, how many grand juries it went through to finally seek an indictment, and then finally, how much the evidence was presented to a jury to try to get her convicted of these crimes. I'm going to talk briefly about the actual charges. We had one count of engaging in organized criminal activity. It was a first-degree felony. There were also the next 6 counts were bribery. Now, the state bar and some other people would like to say, oh my gosh, 6 counts. Any criminal practitioners on the board would be very well aware to know that you could have combined those to 1 count. Then you have money laundering and tampering with the governmental record, which were not included in the first indictment that was handed down in July of 2011. Those 2 were not added until Judge Wooten was offered a Class A misdemeanor plea offer to resign her bench. And when she refused to do that because she wasn't guilty of any crime, then they re-indicted her. Prosecuted for a long time. Felonies, 9 major felonies, and offering a single Class A misdemeanor just to go away.
I'm going to object to counsel testifying. Everything he's talking about is irrelevant to this case.
The evidence will present itself.
May I finish?
Yes, please.
The evidence that he says will show is irrelevant to this case, and so I'm going to object to him putting it before the board at all.
I understand, and I think that's some of the stuff we were talking about before we started. I'm going to let him go ahead and proceed, and we'll carry your objection. If you'd like a running objection, that's fine. If you'd like to go ahead and let it happen a couple more times and make objection, that's fine too. However you want to proceed.
Well, I'd like to do both. I'll have a running objection too.
I will give you a running objection, and it may be helpful to make an objection if there's some reason that it isn't relitigating the elements of the crime. It may be helpful to have him respond. Okay, proceed.
Thank you, sir. For you to exercise your discretion on these convictions, you have to look behind the convictions. If this board just took them at face value and just said, look, she's been convicted of these 9 felonies, then just bar them, then like I said, we wouldn't be here having this hearing. What the State Bar didn't present to you in her opening statement was what actually happened on these alleged convictions by this jury. This jury did not convict her of actually engaging in the crimes that she was alleged of doing, engaging in organized criminal activity statute. They convicted her of conspiring to commit, which any criminal practitioners on the board will understand that if you're convicted of conspiring to commit, then you haven't committed the underlying offenses. So look at the jury's verdict. Conspiracy to commit these crimes, yet they convicted her of the bribery, the money laundering, and the tampering. The verdict doesn't make sense. You hear about at the end when she says that she took a plea offer. The state of Texas in this particular case, and you'll hear evidence from witnesses that talk about whether this case would have withstood appeal. Not even after the first verdict came down on the conspiracy charge, the state of Texas was leaning over going, we'll offer you probation if she waives her right to appeal.
I'd like to object to defense counsel testifying.
There will be evidence that presents itself. The evidence that presents itself that during that hearing, there's transcripts that Mr. White of the Attorney General's office leaned over and said, without even, we're count number 1 out of 9. If you take probation, we'll give you probation if she waives appeal. She waives appeal. Deathly afraid of an appeal in this case. Prosecution in this case, I will submit to this board, is very overzealous. Mr. White was here this morning. I think the Attorney General of Texas has probably better things for him to be doing than being here for a case he's no longer involved with. That's what we've been dealing with, about the overzealousness of this prosecution. When you have a judge that is beat by a newcomer who's best friends with the DA, this is the result. I'm going to ask you to listen to all the evidence, that you're going to hear about what a great woman this woman is, her honesty, her integrity. You're going to hear about the underlying financials. We're not going to relitigate the case, but you're going to hear from a witness who's going to explain that when juries hear about how we elect judges in Texas, it's pretty compelling, but it's the law. I'm going to ask that you listen to all the evidence, exercise your discretion that the rules allow, and suspend. Do not continue the travesty of justice, and just suspend Judge Wooten for the remainder of her probation. Thank you.
Ms. Stevens?
One second.
Oh, sure. Thank you.
You can have just a minute to get my exhibits.
Absolutely.
At this time, I'd like to offer petitioner's exhibits, and I'll go ahead and list those out for the board, if that's okay.
Thank you.
Exhibit number 1 is a certified copy of the grand jury indictment, superseding indictment in the underlying criminal case. Exhibits number 2 through 19 are certified copies of the judgments of conviction by jury / punishment by court, and the corresponding certified copies of the orders suspending imposition of sentence and placing defendant on community supervision in cause numbers 366-81639-2011, counts 1 through 9. Exhibit number 20 is the original affidavit of Rebecca Beth Stevens, attesting to the fact that respondent is the same person as the person identified as the defendant in the underlying criminal cases. And lastly, exhibit number 21 is the original certificate from Blake A. Hawthorne, Clerk of the Supreme Court of Texas, dated September 28, 2012, which indicates that respondent is licensed and authorized to practice law in Texas.
Any objections to exhibits 1 through 21?
No objection.
Exhibits 1 through 21 are admitted.
May I approach?
Please.
At this time, the commission reserves its remaining time for cross-examination and rebuttal.
Mr. Schulte.
That was quick. May it please the board, counsel. I'm going to read portions of a deposition of the Honorable Judge Mark Rush. I know how much everybody hates depositions being read into the record, but there's no other way to do this, so I apologize since those particular witnesses aren't here. On July 20th, 2012, the State Bar noticed the deposition of Judge Mark Rush. He is the judge of the 401st Judicial District Court in Collin County. The deposition was held and it lasted approximately almost 3 hours. I'm obviously not going to read 3 hours of testimony because that would eat up all of my time. So I'm going to read parts of it that I have highlighted out.
I could ask if you would say the page number.
Of course, of course. All right, it's going to start on page 16, line 22, the witness, which is Judge Mark Rush. This is in the fall, Mr. Schulte, of 2009 or early 2010. I don't remember specifically. I couldn't tell you which meeting it was. I don't have any notes that would help me tell you which meeting it was. In the meeting, the only thing that stands out is that Judge Wooten was angry, and at one point in time, she's talking about the district attorney's office and these grand jury subpoenas, and she says in a rather angry tone, they bought them to people they knew, well, it should be they brought them to people they knew that would sign them. And when she did that, she pointed like this, demonstrating across her body. In that meeting about where Mr. Hinton was and about where this court reporter is, but there was nobody between us. So the arm going across her body, pointing to her left, was pointing right at me. And the arm going to her right was to the chair immediately to her right, which was Judge Chris Oldner. I have recollection of my jaw setting and me just checking out just because I was so mad. I'm just not going to respond. I know that Judge Oldner came unglued and it got loud. Exactly what was said by who, I couldn't tell you. That's my recollection of the second one. It was an expression of frustration. And I have no doubt that she was frustrated because I had signed grand jury subpoenas for Oldner's grand jury when he was unavailable, the 401st sitting for the 416th.
Could I ask if you're going to read from depositions that you read the question?
Mm-hmm.
Yes.
Okay, because I don't know if you did that last
There
time.
was the question was it was a narrative response, but yes, I'll read the next question.
Thank you.
It's a hard place to start.
I appreciate that. I'm just for future reference.
The question was, do you remember which court brought the indictment of the first assistant DA in Collin County? This is on page 24.
Wait, can you, just a second. Okay, what line?
Line 11. Which court's grand jury brought back the indictment? I'm not sure.
That's relevance.
We'll carry that for a minute. Let me overrule it for right now, and we'll determine that later.
It was a grand jury impaneled by Judge Wooten. Question, which court? Answer, 380th. Question, and do you know what happened to that indictment? Answer, yes. Question, what? What happened? Answer, I met with the special prosecutor by phone. Defense lawyer was in my chambers. They agreed to personal recognizance bond amount. I set that. Then I recused myself. The case was assigned to another judge, I believe in Longview. I think it was in Longview. And then the judge in Longview subsequently, with a very short period of time, quashed the indictment. Page 26, line 18. This is the direct examination by Ms. Stevens. Question, would you please state for the board about whether or not you have an opinion whether it should be suspended or disbarred?
Could you read it actually as how it's written?
I did. Do you have an opinion as whether she should be suspended or disbarred?
Okay, I thought you said 18, that was line 15.
Answer, I do. Question, would you please state that for the board? Answer, I think Suzanne should be disbarred. Question, and would you tell me why, please? Answer, Suzanne's convicted of 9 felonies of moral turpitude, 6 of which are bribery accounts. In my opinion, the absolute worst thing you can say about a judge is that he or she can be bought. Bought. I'm sorry, Mr. Hinton, I'm mumbling. 12 citizens of this county heard evidence. I don't know what the evidence was. I wasn't there. I haven't seen it. I haven't read the indictment. Suzanne's friends of mine. I like her a lot. My analogy is baseball. There's one rule in baseball. You don't bet on the game. Pete Rose bet on the game. I don't care if that's an arcane rule from the outflow of 1919. Judge likes to ramble, I apologize. I don't care that we are enlightened and we have gambling everywhere in the world, and it's no longer the moral sin than it was in the early 1920s. Everybody who knows anything about baseball, and every kid who loves the game, starting about age 10, knows that you don't bet on the game. If you do, you don't get in the hall. Pete Rose bet on the game. He didn't get in the hall. Suzanne was convicted of bribery 6 times. False report, money laundering. It's a scary title. The elements are different. I know it's conspiracy, but I don't know what it's a conspiracy to or what the crime was. I haven't read the indictment. I know it was a lesser included of an engaging count. I don't know what the underlying engaging accusation was. I know it's a 3rd-degree felony versus a 1st-degree felony. I know she accepted some level of responsibility when she waived her right to appeal. I'm an experienced criminal law guy. I'm board certified. I was a prosecutor for 12 and a half years. I've been a judge for 15 and a half. I understand the various tactical reasons why sentences get entered. I don't think she would have gone 9 for 9 on appeal.
Objection relevance.
She may have very well have beaten the bribery counts, because my understanding of the statutes, what the courthouse rumor is, the evidence doesn't come anywhere close to meeting the statutory definition of bribery.
I'd also object to speculation.
Overruled.
The witness, Judge Rush, do you want to know why? Okay. She's got 9 felonies of moral turpitude, 9, and she waived her right to appeal. If you're not good for it, you don't let anybody say you can be bought if you're a judge. You don't, and when you accept responsibility, I know she didn't say I did it, but she said something enough that allowed the judge to say, good enough for acceptance of responsibility. I'll put you on probation, and then you get to waive your right to appeal. You don't get to later on and complain and collaterally attack. You're good for 6 briberies, and if you're good for 6 bribery counts, you don't get to keep your law license. It doesn't matter how much I like her. It doesn't matter how much I think of her. You don't get to keep your law license. It's on page 45. Sorry, on line 9. Question. This was by me. Was Suzanne the type of woman that wanted to protect the integrity of the justice system? Answer, I thought so. Question, okay. The second judges, the second meeting, did you have a grand jury impaneled in the fall of 2009? Answer, in the fall of when? Question, 2009. Was that your grand jury, Tom Baird? Answer, no, that was Chris Oldner's. Chris Oldner's. Are you good friends with Tom Baird? Answer, yes. Did you have conversations with Tom Baird about what was going on in the grand jury? Answer, no.
Objection relevance, and should I just have a running objection on this?
However you want to do it. I'm kind of at the point where I would like to hear what your argument is. I know, we take as true, and it's conclusive evidence, the conviction which has been introduced, and how that conviction got there. Why is that relevant?
It's relevant because I understand that the convictions are in front of this board, but I think this board needs to understand that sometimes juries get it wrong. I'm not going to relitigate the issues, but I want you to understand that when a jury sees the type of overzealous prosecution that comes forward in these cases, and they convict because the DA indicted her, this board has to look behind the convictions to exercise their discretion. I'm just trying to give you an eye about what's happening in the background. I understand the convictions are there.
And you understand they're conclusive.
I understand.
May I respond to his
Yes.
objection, or his response? He said that the juries get it wrong. He's not trying to relitigate, but that's precisely what that would be. That's an appellate issue. She's waived her right to appeal, and it's a moot point and should not be brought in front of the board.
Can I ask a question?
Absolutely.
How do you know that the jury convicted because there was an indictment?
They told me.
They told you, is there a record?
Mr. White, who was the Attorney General, was present in the room. There's not a record. It was after the jury verdict. They said they just wouldn't have, the DA wouldn't have indicted her unless she was good for it. We struck 49.
They found 12 jurors that were willing to convict just because there was an indictment?
Mr. Gerwitz, out of the 150 veneermen, we struck over 45 of them for presumption of innocence. And we thought the 12 that we had would not hold it against her.
But you let 12 people get on the jury who were willing to convict just because there was an indictment?
They didn't tell me they were going to do that.
And surely you asked that question.
Of course I did. We struck 49 of them. And these 12 made it through.
And let me ask you one other thing. I thought you said the indictment was conspiracy and not the actual act?
Let me clarify that.
Because I've read the indictment, and the indictment is not conspiracy. It's
Correct. She was not convicted of the engaging. She was convicted of the lesser included of conspiring to commit. So my point was in my opening, sir, was that if she was conspiring to commit, and then the jury found her guilty of the underlying offenses, those verdicts don't meet up. Either she did it or she didn't. You can't say she conspired to commit and then convict her of the underlying bribery.
Ms. Stevens?
It's the commission's position that all of this are appellate issues, most of the new trial issues that are not relevant before this board.
I understand, and I understand your logic. We're gonna go ahead and let him proceed.
Thank you.
Thank you. Any other questions at this point? Okay.
All right, this is on page 54, beginning on line 24. Question, do you think Judge Wooten was trying to interfere with the grand jury? Answer, in the second meeting. Question, yes. Answer, do I think in either of those statements she was trying to? I do not. I did not then. I do not now. Question, okay, I just wanted to make sure because that's the impression I got. Answer, I have colleagues who believe that. That wasn't my impression at the time.
I'm sorry, can I ask what page you're on?
54, moving to 55. It was on page 54, starting on line 24.
I didn't quite catch
Okay,
up with you.
it's fair. I'm just repeating it. Question, this is on page 67, beginning on line 25, continuing to page 68. Question, okay, now let's talk about the 6 counts of bribery against Judge Wooten. Now, you're very familiar with criminal law. Answer, I'm board certified. Yes, sir. Question, just like the money laundering statute where they accumulated the particular amount of money, they could have done it with a bribery as well. We could have been looking at 1 count of bribery. Is that correct? Answer, Could, the grand jury could return as few as 1 or as many of 1,000 plus 1,000.
I'm gonna object to relevance, and I'd like to have the running objection to all of this line of questioning. And the
We're
testimony.
gonna overrule the objection and grant a running objection.
Question, and is it your opinion, based on everything, that if Judge Wooten had appealed, her case is that she probably would have gotten the 6 counts of bribery to be overturned?
And at that point, I objected to form, and I'd like to clarify that I'm objecting to calls for speculation.
Overruled.
Question, let me rephrase, answer, okay. Question, do you think, is it your opinion that if the appellate courts had looked at the bribery counts, I'm just following up what you said on direct, that the bribery counts would have been overturned on appeal?
And again, I objected to form, just so it's clear for the board.
Okay, overruled.
Top of page 69, line 1. Answer, if, little word, huge meaning, if the evidence that the jury heard is where the criminal defense bar of Collin County was relating, then I don't know how that jury found Judge Wooten guilty of bribery. And if the criminal defense bar is accurately relating to the evidence the state of Texas presented in that courtroom, that it doesn't conform with the bribery as the statute is written, or as the appellate courts have interpreted it as I have researched the bribery statute. Question, what was your understanding about what the evidence was presented? What was the argument? What was the argument by the state? Answer, I don't know what the argument was by the state. I wasn't there. I didn't. Question, what was your understanding to come to that conclusion about what were the facts? What were they? Answer, pretty much to a person, every criminal defense lawyer who came to my office after the verdict came down and said they didn't present any evidence of bribery. Question, matter of fact, you haven't seen the indictment? Answer, and basically on bribery statutes, do you think in most cases, and the cases that you've read, does the person who's allegedly bribed, don't they have to receive money in return for something? Answer, that's usually how it's done. Question, bribery usually is seen as somebody in the back of a church with an envelope full of $10,000 cash going wink, wink, I've got the city council taken care of.
I don't want the board to think I'm silent on this. I'm objecting to relevance. This is an attack of the underlying conviction.
Thank you.
Convictions, excuse me.
Yeah, and we understand, and I think even though you have a running objection too, this is a trial of the bench, and even without objection, we are free to not consider irrelevant testimony.
Answer, the Abscom, the motel room, the suitcase, yes. Yes, that's bribery. Question, this is page 70, line 17. The questions are whether or not you think Judge Wooten should be disbarred. Let's state that you know. Does it change anything thinking they didn't prove bribery? If she didn't have the 6 bribery counts, would you be giving a different argument to the state bar about whether or not she should retain her license? I don't know. Question, and why not? Answer, because I don't. I haven't thought about it. Question, the only reason I ask is that it seems on direct you were very much focused on the bribery statutes. Answer, that is the thing that most personally offensive to me as a judge, okay? I can tell you my reasons. It would depend on on how many other statutes were still standing and what the egregiousness of that conduct. Question, is it your understanding that Judge Wooten changed her plea in this case? Answer, no. This is on page 74, line 9. Question, do you think that Judge Wooten was given money in exchange for favorable rulings on the bench? Answer, I don't know. Question, you don't know? Do you know the underlying premise of the money laundering allegation? Answer, nope. Question, do you know if Judge Wooten received any money from these alleged litigants? Answer, I know. I have been told of one $50,000 check that her campaign received. Question, directly? Answer, I don't know. Question, if you found out that it was never received directly, would that change your opinion today? Answer, no. Question, Judge Rush, do you have any opinion or knowledge that Judge Wooten had any knowledge intentionally knowingly received money from these individuals for the benefit of her campaign? Answer, Suzanne never told me that. I was not a witness to any of that. I have not seen any of the evidence. So the answer to your question is I have no personal knowledge of that. Page 75, line 18, line 20. Question, now your understanding of the tampering charge. You said that you felt like, based on your knowledge that she was good for it. What's your basis? Answer, yeah, that was our conversation. Question, yes, what was your understanding of that, or how did you come to that conclusion? Answer, Suzanne had pretty much told anybody who would listen, told me on more than one occasion that she had edited her reports and found 4 instances where she had failed to report or failed to disclose that she had corrected that and brought it to the attention of the Ethics Commission, who said, no problem, thanks. And if there's ever a complaint filed, we'll take it into account that you self-reported this. General rule, when you're dealing with paper and reports, lack of entries of things, failing to report things is a very, very, very easy thing to prove. The same criminal defense bar who was scratching its head about the bribery convictions to a person has said, there's no question that the state proved that charge. Question, okay, let me make sure I understand. So you thought, let's talk about the campaign finance reports. You thought that the underlying tampering of a governmental record was because of the campaign finance filings. Is that true? Answer, yes. Did you know it was not those? It was actually her personal financial statement. Okay, no. That she didn't allegedly report the alleged bribe as a loan on her personal financial statement. Would that change, knowing that, would that change your opinion about whether or not she was good for the tampering charge? That's easy. Answer, that's easy. Question, why is that easy? Answer, because if it's not there, it's not there. Question, but she would have to say she knowingly accepted the money, correct? Answer, you would have to be aware that you have the money to report, yes. Question, right. So if she had no knowledge that her campaign was indirectly receiving the benefit, then it wouldn't be a crime for her not to put it on her personal financial statement. Answer, if she didn't know she had the money to report, she couldn't report it. Question, correct. So would that change your opinion if that was the truth? Answer, if the truth is she didn't know she received some form of cash, it would be gosh darn difficult thing to prove that she intentionally and knowingly made a false report. Question, now you know why I'm scratching my head.
And at that point, I objected to form, because that was not a question.
So,
I'm moving on.
Yeah.
This is on page 78, line 13. Question. That's what you've heard, but if it isn't true that a $50,000 check was never received by the campaign, was never received directly by Judge Wooten, would that change your opinion of why you're sitting here today? A, answer, no, that would be why you're looking at the money laundering charge. Question, do you know the basis for the money laundering charge? Answer, no. But if your money is coming in indirectly to your campaign, say the money is going to a third party or a campaign manager or otherwise, and you're trying to keep that world from knowing that, and then you get to funnel that money into your campaign, then you would get into trouble. Question, right. So that's money laundering. So how do you turn that into an intentional crime where she's allegedly taken money for a bribe? She has to have some knowledge, correct, for it to be a bribe, intentionally and knowingly? Answer, that's what intentionally knowingly means, yes. Conscious objective or desire to engage in the conduct or cause the result or where those circumstances exist, yes. Question, so how do you reconcile that with the money laundering where she still got to know the money is there? Then that doesn't rectify with the tampering charge, does it? The witness, if you're asking for a theory of which I can get you from there to here, sure. Do I know what the facts of the case are? Heavens, no. And finally, on page 84, line 9, there was just some brief synopsis why we're actually getting into this. Judge Rush made some comments about judges' meetings, and there's some differing
Object
between,
to Respondent's counsel testifying.
not testifying, I'm just I'm giving an understanding of why I'm actually going into this brief portion of the deposition.
I understand the objection, I'm gonna go ahead and overrule it.
There's been some conflict about these judges' meetings that were occurring in 2009 and 2010, and this is just kind of relevant to that area. On recross by me, question again, Mr. Judge Rush, just to reiterate, the second and third meeting, I'm going to say they happened in 2010 in the spring. The State Bar really wants you to say in the fall of 2009. Objection. But you don't recall. Answer, it's a force of habit. When somebody says objection, I respond, I apologize, everybody, I apologize. I really don't recall. And there's not a set of notes someplace that I wrote down when I can look and give you the exact date. All right. That's like I said, this was a 100-page deposition. It was most of the excerpts that I could of that particular transcript. The next one that I'm going to read from
Any
is...
cross-examination from the deposition?
No, Your Honor.
Sorry.
Or,
Okay.
Mr. Chair. Sorry.
That habit. So
Thank
one thing of watching all the videos is, that's everybody says, Your Honor.
Yeah.
It's the habit.
I understand.
So I apologize if I do the same. The next thing I'm going to read from, it's not going to be as long. Like I said, I'm a criminal defense lawyer. I hate reading from depositions, but I'm going to do my best. This is from Judge Cynthia Wheelis. This is another district judge in Collin County. She is the 417th Judicial District Court out of Collin County. And she was noticed for a deposition and subpoenaed by the respondent in this case, and these were held on October 5th. This is on page 12, starting on line 15. Question, now at some point after the fall of 09, or after that grand jury, would you agree with me that the fall of 2009 grand jury did not indict Judge Wooten? Answer, correct. Question, do you know of anybody that had any conversations with any of the members of the grand jury?
I'm going to object to relevance and calls for speculation, and I'd like a running objection to this testimony for this witness as well.
Your objection is overruled, your running objection is granted.
Thank you.
Answer, do you know of any conversations? Question, did you have any personal knowledge of anybody else who's having conversations with the grand jurors? Answer, I don't believe so. I'm thinking of Judge Rush helping to write a memo. Question, okay, in that memo, what was your understanding of what that memo was? Answer, that memo, in my understanding, I've seen the written document, was a grand jury's proclamation that they were not proceeding against another judge, Judge Greg Willis, that he had done nothing wrong. Question, okay, so you saw the final version of that memo, is that correct? Answer, that's correct. Question, did you come to have any knowledge about whether or not any other judge had items removed from that memorandum regarding Judge Wooten's investigation? Answer, I do not. Question, okay, in the spring of 2010, so right after the new year, what was your understanding of the investigation of Judge Wooten? Like, was it still proceeding or was it over? Answer, well, okay, I practice criminal law. I knew the ability to represent, that there being no true bill of indictment, but that it's very hard to read this. I don't know what the nature of it was, but I thought it was over, yes. Question, okay, so at that point, so it wasn't unreasonable for you and the other judges to think that things were hopefully going to finally get back to normal. Answer, yes, I believe so. Question, okay, and did you have conversations with Judge Wooten at that time period about her also believing that the investigation was over? Answer, yes. Page 17, beginning on line 25. Question, did you believe that Judge Wooten was trying to interfere with the ongoing grand jury investigation? Answer, did I believe that she was trying to interfere? No. Did I believe she was unaware of the criminal law? Question, yeah, let's talk about that. You said you believe she was just not familiar with the criminal law in that regard. Answer, I believe that her concerns regarding whether or not people were reading the things that were signing were unfounded. Question, okay, let me ask you about this. Did any other judge express concern to you that they felt like Judge Wooten was trying to interfere with the grand jury investigation?
I'll object to hearsay on that part.
Overruled.
Answer, I don't remember another judge saying that she was trying to interfere. No. Question, and the reason I'm asking is it was alluded in Judge Rush's deposition that he believed that those conversations that were being held in the judges' meetings were an attempt by Judge Wooten to interfere with that process. You don't feel the same way. Answer, no. Question, okay. Answer, if anything, ignorance is my understanding. Question, did Judge Wooten ever express to you that she believed she was guilty of these charges? Answer, no. Question, did she maintain her innocence throughout the entire period? A, meaning the indicted charges, correct? Question, yes. Yes, she maintained her innocence throughout. Okay, moving on to page 20. line 10.
Yeah.
Question, do you, as part of this process, Judge Rush was asked whether or not he believes that Judge Wooten should be disbarred. And in his deposition, he said yes. Do you have an opinion either way? Answer, I think she's a great attorney. I'd like for her to be able to go back to the practice of law. Question, did you, this is something that just was shown to me, but did you know about any plea offer that was offered to Judge Wooten prior to her trial? Answer, yes. And what was that plea offer?
Objection to relevance.
Overruled.
Answer, I wasn't on that conversation. Answer, but I did understand that she was offered, I believe, it's just my belief, a misdemeanor deferred or a misdemeanor keeping her law license. Question, was there any stipulation that she had to leave the bench or not? Question, yes, absolutely. Question, so your understanding is that a single misdemeanor, whether it was deferred or not, we don't know, or you don't know, plus her resignation? Answer, that is my understanding, but keep her law license. Question, but keep her law license, that was prior to this case going to trial? Answer, yes. Question, do you have any personal knowledge of who extended the plea offer? Let me rephrase that. And do you know who extended that plea offer only if you have personal knowledge? Answer, I do not. Page 23, line 9. Notwithstanding the jury's verdict, do you believe that Judge Wooten is guilty of what she was charged with? Answer, I have no idea, honestly, I have no idea. All right, that's the conclusion. That was a roughly 40-page deposition of Judge Wooten's witness.
Any cross-examination from the,
No questions, please.
Could you restate who the two deponents were? Just and spell their names for me.
Yes, sir.
I'm sorry.
The first one is Judge Mark Rush, R-U-S-C-H. He is the judge of the 401st Judicial District Court in Collin County. And the next one is Judge Cynthia Wheelis, W-H-E-L-E-S-S. She is the judge of the 417th Judicial District Court in Collin County.
Thank you.
Sorry about that. Like I said, I'm not used to depots.
Okay, I'm just trying to keep all the players straight.
Thank you. Next witness that I have is Judge Chris Oldner, O-L-D-N-E-R. He is the judge of the 416th Judicial District Court in Collin County. This one is going to be a lot shorter, and then we'll be done with the depositions. This goes back to the judges' meetings again. Page 27, line 2. Question. Do you believe at all during the time of the spring of 2010, during the judges' meetings, there's been some, I guess you can read for some of these depositions that maybe one or two particular judges believed that Judge Wooten was trying to use her influence as a judge to interfere with an ongoing grand jury investigation. Did you have those feelings? Answer. I don't think I would put it in those terms, no. I think she was upset, distraught. I think she was searching a little bit about what to do and seeking advice on what to do. And she would offer up options, more than one at a time. This issue of a court of inquiry came up with both you and Suzanne. Question right. Answer. And so Suzanne has known me for a long time. I don't think for a second she thinks that I would do anything that I thought would be inappropriate. So I never felt that like she was trying to pressure me for sure in any way. But I do think she was upset, and I think she wanted the judges to have her back, and that I didn't think that necessarily naturally flows to, say, tamper with the grand jury or interfere with an investigation. I think she wanted us to stand united. I think she wanted us as a unit to stand cohesively, and I don't think she was getting that from us, and she was disappointed. It disappointed her and upset her. That's at least what I took from it. Question. Now, what kind of lawyer was Judge Wooten? Answer. You mean what type of law did she? Question, yeah, like was she ethical? Answer, I have. I've never been aware of anything unethical she's done. Question, what about, did you have anything that she did when she was practicing attorney that made you question her integrity? Answer, she was aggressive, but that certainly is not unethical or any indication that your integrity is in question. So that's not that I'm aware of. Question, when you heard about the allegation that she was charged with bribery and those sort of allegations, did you believe that it was in her character to be bribed? Answer, no, honestly, I didn't believe it. I didn't want it to be true, and I didn't believe it. Question, you didn't believe it? Answer, because I've known her for 15 years, I wouldn't. That's not the kind of person I would choose to have as a friend. And if I thought somebody who would do that, and again, we weren't, buddies, we didn't hang out at each other's houses very often, but we'd been to bar organizations together and done other things, and I've not seen anything that would lead me to believe that she would do that. Question, did she, to the best of with you at least, did she maintain her innocence throughout the entire process? Answer, yes, absolutely. Page 37, 19. Question, do you have any opinion, if you do, Judge Oldner, about whether or not you think Judge Wooten should be disbarred? Sorry to put you on the spot. Answer, well, that's just a hard question because I have two different opinions. I mean, as a friend, as a father of 3 kids, I hate to see anybody lose their way of earning a living because I know she loves her kids, I know she loves her family, and she was a good lawyer. As a lawyer, I mean, you know, as a judge, when you're part of a profession that's charged with policing itself, I have a hard time seeing how to avoid it. Question, well, let me ask you, stop you there just to say, are you aware that the rules allow that if a person receives a fully probated sentence, that the Board of Disciplinary Appeals has the ability to suspend a license throughout the time of probation? Are you aware of that rule? Answer, honestly, no. Question, okay, well, let's say that is the rule. They've either suspend during the time of probation if the sentence is fully probated or disbar. Do you have an opinion of either one of those options? You might have asked a question back. Go ahead. Even if there's disbarment, is there a way to reapply? This is when the state bar steps in and says, I'll just go ahead and tell you that the rules, I understand it. After 5 years after disbarment, you can reapply, retake the bar exam. Then I say, retake the bar, and the bar says, oh, you have the bar though. Anyway, sorry about that. Question, go ahead, answer. Well, I thought there was, but I wasn't sure. Again, I'm torn about it because as a friend, again, and as somebody who knows that you get to pay your mortgage and pay your light bill and keep your kids clothed, I'd hate to see her not be able to do that throughout the practice of law, which is why I think she was successful and good at. If I were a lawyer who did not know Suzanne, I'd say, how could you not disbar her for that? That's if you didn't know her. But I do know her, so I'm torn. I'm just torn. Question, do you think because it goes back to the integrity and the character that you know of Suzanne? Answer, again, up until the point of conviction, I didn't think she did it. And then finally on page 40, line 17, question. Again, the allocution, I mean, she confessed to the commission of the acts alleged. And if that didn't occur, then question, let's say it didn't. Let's say that it didn't, and answer. Then I have to fall back on the issue that, again, my career has been dedicated to the jury system. And I'm a big believer and strong believer in the jury system. I personally don't ever want to believe that, not only as a colleague, but as a friend, that she would have done that. But a jury has found her guilty. Well, question, I hate to ask this question of a district judge, answer, but you're gonna. Question, I'm going, of course, have juries ever got it wrong? Answer, sure, absolutely. Pass the witness.
No questions at this time.
Can I have a brief 5-minute recess to go outside and get my witnesses rounded up?
Absolutely.
Can I get a check of time? Really? I was reading fast.
Yeah, why don't we take a brief 5-minute recess, and you can get your witnesses lined up, and we'll be back in 5 minutes.